Ask this basic question as you go through risk and opportunity. How do risks intersect with compliance mandates? It's actually a form of risk insensitivity to be unaware or unwilling to confront the risks that are associated with compliance mandates. So, for example, I ask this question every single day. Is what we're doing in Title IX making things better for people, or is it making it worse? Those are hard questions to answer, but they have to be examined. We have to look at the core risks that we're doing. If we pass an alcohol policy, does it simply drive students off campus to more risky behavior? If we accept without critically attacking the Garcetti Doctrine that limits the speech of many student affairs professionals, are we creating a less academically sound environment? We need to ask these questions every single day. These are the important questions. I've constructed 6 postulates of academic risk management. These are just postulates. Let's chew on them. Maybe you'll have others. I wish that you would. I'm trying to tweak you to do this. And I hope you'll criticize this and critique it and discuss it. And it's the whole point is to get us thinking about these things. So here are my postulates, Lake's 6 postulates, I suppose. I believe that every risk in the academy has at least one appropriate academic response. That for everything that we experience that we think is a challenge or opportunity, there is at least one appropriate academic response. What does that look like? Well, back to Title IX for a moment. I think one clear academic response to Title IX issues on campus is to improve training and education around human interpersonal contact. It could be as basic as teaching people just the contours of respect and consent. I also believe that academic responses to risk have greater long-term promise to generate risk reduction than many non-academic responses. And again, I live in many worlds. I'm a lawyer, but I'm primarily a teacher. And I deeply believe in educational power. I'll make no mistake of this, or certainly won't hide this from you. I'm a huge fan of Robert F. Kennedy. He inspired me when I was a kid. It's probably the reason I went to law school. And I remember him as a child, and he said some really interesting things as a lawyer, as the person whose name is on the Justice Department building in Washington, D.C. He said, the solution to the mindless menace of violence in society is education and compassion. And I thought that's a very interesting thing for a lawyer to say, that to stop violence, we don't need more litigation and prisons. We need more education and compassion. I've never forgot that lesson, and it stuck with me my whole life. I deeply believe in it. Do you believe in that? Well, that's up to you. But I'd like you to at least postulate the possibility that in the long run, we have better solutions to what are presented to us as compliance mandates than legal authorities ever could come up with. That for everything that they come up with a legal rule, we can do it a little bit better, maybe a lot better. Next postulate. When we don't manage risk with appropriate academic responses, it externalizes. And so I've watched this in my career. For over 20 years, I've been warning campuses, if we don't address college safety and establish basic, clear guidelines for reasonable safety on campus, we will find ourselves in an accountability crisis. And I tried to say it as nicely as I could, but I kept reminding people that this will externalize, and it's exactly what has occurred. Because we waited a while to get around to some of these issues, we find ourselves now subjects to external control and restraint. When Hogwarts lost control of Lord Voldemort, the Ministry of Magic arrived, and the Muggles got a lot more interested in what we were doing in wizard school. Higher learning is inherently risky. I don't know why we hide this. We almost want to make people think that they're coming to college on a sunny day where everybody's happy and everything just goes idyllically well. Perhaps it's attracting people to some consumer image. I don't really know. But the reality is that higher learning is very risky. You run the risk of seeing your limitations. You run the risk of being humiliated. You run physical risks. You run the risk of being confronted with cultural norms that conflict with yours, that may challenge you and even upset you. This is risky business. And there's no point in trying to hide the fact that the traditional age college student in particular has always gone through a risk. My uncle's generation didn't really have the privilege or opportunity of college. Their college experience was to be shipped out to fight fascism and global dictatorship and evil empires, and many of those young people didn't come back from that. It was extremely dangerous. Their education is very risky. This generation, I think, has a different kind of challenge. Every generation does. But let's not try to pretend that higher education isn't inherently risky. In risk, there's opportunity. Risk management is an academic virtue. I was working with one board, and the board member said, why should we do this? Why should we do this risk management stuff? And the answer to me was very clear, although I don't think it necessarily was to that person. I think risk management's an academic virtue. We really are engaged in a business of risk management. We just don't necessarily conceptualize it that way. But everything we do is designed to show that we care about our students and our compatriots. It's also designed to reduce risk and to help people learn how to enter a very dangerous and complex world and make responsible and better choices for themselves and their families. It goes to the core of who we are. And finally, I believe that qualified students who engage in unreasonable risk in the academy usually have issues related to intentionality, planning, or mentoring. If you've read my book, Beyond Discipline, I go on and on about this as a core theory. It's based on my own experience as a discipline officer and teacher. Yes, there are a handful of students in the academy who simply don't belong in our environment. They are sociopathic, may have criminal tendencies. They don't really belong here. They didn't really come here for the purposes for which our institutions were created. I'm always averse to kicking someone out unless it's absolutely necessary. I have an educator's instinct, probably you do too, but there are some people that do need to leave. However, a very large range of students who end up in trouble, who become compliance issues or risk management issues, it comes down to three things. Usually it's intentionality. I don't know who I am or where I'm going. I don't have a good plan, or I was poorly mentored. I see it in law school sometimes with students that are challenged, and I ask them, why'd you come to law school? I don't know, my parents wanted me to be a lawyer. Well, do you want to be a lawyer? And boy, if you're not on the right pathway, if this isn't something that motivates you, all of a sudden risk starts to be generated and compliance issues tend to follow suit. Planning. Now, a lot of folks just don't engage in the necessary planning for the higher education experience. And of course, part of that is accepting the risks that go with education. And so when we meet those challenges, we're not prepared to meet them. We don't have a plan in place and the types of support that we need to do it. And then mentoring. And I see everything from great mentoring to de-mentoring in this field. I've seen some pretty disturbing examples of people who've been mentored to the dark side, and it ruins their higher education experience. With great mentoring, we get different results. When you know who you are and what you want, or have a better sense of that, when you make a reasonable plan that you can revise as life throws its new challenges at you, and when you have a strong mentor group, you tend to thrive in higher education. When one or all of these goes off track, we start to see risk management and challenge issues arise. So here's a risk map, because you've got to have a map. People use these kinds of metrics. It's just something I pulled from AGB and Nakubo. It helps you to schematize risk and to think, looking at probability and impact, what am I going to focus on? The purpose of this is really to get people to think constructively about what are the low-risk situations that I'm willing to accept? What are the ones that I can control? What ones do I need to share to have any hope to manage? And which ones do I really need to step on top of immediately because there's high risk and high impact? Again, every campus will come up with a different ranking, and this isn't about getting the right answer. It's about going through the process of analyzing risk in this way. Risk management is everyone's job, as is compliance. And this is the new world that we live in. In Compliance U, every employee comes to work and says, I'm an agent of risk management, I'm an agent of compliance. It's what I do, it's part of my job. And it's not something imposed on me, it's not a pain in the neck. It's actually something I want to do because it's who I am. It's an academic virtue. So I've listed just about everybody here that we can think of, probably missed a few folks. I just think it's important for us to get this message across that compliance is not the job of the chief compliance officer only, and risk management is not the job of just the ERM director. It might help to talk about roles for just a minute, the role of the general counsel, GC, and or the chief compliance officer, CCO, or sometimes referred to as the chief policy officer, the CPO. When we have centralized policy compliance, we often see a chief compliance officer. The truth is, in another generation, general counsels often routinely operated both as counsel and chief compliance officer, which increasingly has become a challenge in the new compliance university world that we live in. And I'll show you why, and I think it becomes a little more obvious as we dig into it. Lawyers are supposed to give legal advice and counseling. We actually aren't truly allowed to be the principal of a business, an agent, or an administrator. And when you turn your general counsel into some kind of super administrator, you actually push the general counsel away from the very professional mandates that we're trained in law school to follow. We're actually taught to not make decisions for you, not to be the manager. We can guide and advise you. But the more you do lawyer counseling, and I've done plenty of it in my lifetime, the more you learn to trust your client's instincts, even if they don't take your advice, and how critical it is to maintain client autonomy, even in the face of what you might think is obvious advice, what you think would be best for them. It's not my job as a lawyer to think for you or to choose for you. It's to advise and to help structure your choices. The other thing that gets very confusing is if a lawyer is trying to play the role of chief compliance or policy officer, in the lawyer representation dimension, our relationship with clients is confidential. When we're managing a business, it's not. And that can get actually operationally very confusing if people aren't sure, what hat are you wearing today? Are you playing the role of administrator, or are you playing the role of lawyer? Looking at it from a slightly different lens, just the other way to see this, the chief compliance officer is an administrator and an agent of the university. There is no attorney-client privilege, and I think it's equally dangerous to turn your chief compliance officer, who might have a legal degree, into your college attorney. And these days, because people are so starved for legal advice, they're likely to try to seek it from a board member or a chief compliance officer or even colleagues who have JDs. And it's really not fair or appropriate to do that any more than one would go seek counseling advice from a friend over a lunch meeting. It really should be done in the appropriate environment under the proper strictures. When we compare and contrast the general counsel with a chief compliance officer, you will notice that the general counsel, of course, will have a JD, a Juris Doctorate, typically will be very experienced. On the flip side, your CCO might have a JD, and increasingly people do, but it's not necessary to have that, to do that job, and a lot of folks do the job really well. In fact, it has certain advantages sometimes if you're not a JD. We could examine that if you wanted to go deeper into it. A counsel advises, they collaborate with client on policy development, they offer input on legal and non-legal implications of the advice. And I think one of the most important things that lawyers help people do is to see the difference between a legal issue and what's not a legal issue. It's very tempting to sublimate issues, to take something that's a simple policy issue and turn it into a complex legal issue, or vice versa. Lawyers can help with that. On the flip side, your CCO is typically managing projects and often dealing with investigations, internal and external. So we're looking at a more administrative role. The general counsel's job is to anticipate trends and developments in the law and continuously participate in continuing legal education. I will tell you today, it's almost impossible to keep up with everything as a good higher education attorney. NACUA, the College Attorneys Group, does a heroic job of trying to keep their membership up to date And it seems like the law is changing so fast and so detailed that it really challenges people to do that. It means that's going to be a big function of the general counsel's office, is to say, hey, folks, here's a big change that's coming down the road. For example, when the new FLSA regulations were promulgated, this is a major change in overtime rules. And lawyers, it's their job to see what the implications of that might be and where this is heading. Lawyers are typically involved in the preparation of documents, reviewing documents, looking at things from a legal perspective. And of course, our training as lawyers is to look at the letter of the law and to focus on compliance, particularly evidence of compliance. So for a lawyer, just in case that isn't obvious to everyone, in our world, it didn't happen if you can't prove it. So we often are thinking about strict compliance with the law and evidence and how we would construct an argument to a regulator in court that we actually did something, because just doing it isn't enough. We've got to prove and demonstrate that we did. Flip over to the CCO, and you're looking at a lot of training, overseeing compliance staff, monitoring compliance efforts, identifying promising practices, working with consultants, and engaging in CE, continuing education, which sometimes has a legal component to it. There are identification processes for compliance challenges, and I think a really good CCO helps a campus understand where some of the compliance challenges lie. What are the inconsistencies in federal and state metrics? Where are we resource challenged? What's coming down the road in compliance? A little different from the lawyer's perspective. And of course, from my perspective, the CCO really has to get people to internalize compliance. It's just not good enough that the chief compliance officer is watching everything. We have to make sure everyone knows their job and has internalized the spirit of the law and the spirit of compliance. We've got to inspire people to the mission of compliance, and the chief compliance officer in many ways is that type of cheerleader. Conflicts of interest. More and more people are talking about conflicts of interest in the field, and you can see why. And I'll tell you, part of it comes right down to one very basic issue, is the mission statements that we have. Many of our mission statements, either at a departmental level or even at an institutional level, were not designed or drawn up around compliance mandates. And therefore, when we comply, interestingly enough, it arises from a duty of obedience that the Board of Overseers, Governors, or Visitors has to ensure that we comply with the law. What does that mean? It means our populations figure something out really quickly, that we might be doing our compliance work not because it's who we are or what we want to do, but because we have to be obedient. Going back to the very first slides where we talked about the definition of compliance, we've kind of set ourselves up for a sincerity issue. And you will notice that people will challenge this on campus. They'll say, are you doing this because you care about us, or are you just simply trying to avoid being audited, investigated, or sued? Until our missions rectify with our compliance mission, we may find ourselves in a perpetual sincerity challenge. And it's a kind of conflict of interest that is visible both at micro and macro levels. Now let's be more technical. We can see bias in issues. And occasionally we'll see folks who are performing compliance functions who have a bias or other hard conflict of interest, which disables them from that kind of work. We obviously need processes to be able to identify bias, what we think are the important dimensions of bias or impartiality, and to manage those. Professional standards. Very often our professional standards put us in a direct conflict with certain types of work. And I'll take you very clearly to Title IX for just a moment. If you represent an institution as a lawyer, you have to operate for the best interests of the institution. If the federal government tells us that the Title IX operation is independent, which they have in guidance repeatedly, then it may be difficult to advise the institution and the Title IX system at the same time. Professional standards may come into play, and I do think that we're going to see more. We've already started to see it, actually. We're going to see more issues specifically related to professional conduct. Can you, in good conscience, in accordance with professional standards, represent or operate in one dimension and also in another dimension at the same time? We used to not have so many of these issues, but they're becoming much more manifest in Compliance University. Title IX really is an independent auditor, and I think this really does illustrate this. I've already seen conflicts of this type beginning to arise. Communicating with regulators in Compliance University. I think we should take a little time to do a little Rosetta Stone. When we interact with the federal government in compliance work, we often deal with the two big robots. And again, I don't mean to denigrate the Department of Ed or the Department of Justice. I have tremendous respect for both. But the reason I picked the term robot is these are entities that operate in a very programmed, policy-oriented way. And they actually have very predictable behavior because they operate in extremely rule-like ways that aren't always visible because they don't necessarily broadcast the rules that they're operating under, but you are dealing with programmed entities. And so they do have a robotic feel to them. And occasionally it's kind of amusing to watch people interact with these entities when they don't recognize that, because they don't realize that you can push the robot all you want and it's going to respond a certain way every single time. Just because you don't like the response doesn't mean the robot will change its behavior. So I thought we might take a minute just to talk about the culture of the people who regulate us and how we communicate with those entities. And it's actually something a lot of us skip over and go straight to the communication without actually taking the time to consider how the communication is structured. As educators, we think about these things. So let's go to the Department of Ed for a moment. Let's be honest, this was a K-12 unit before 2008, primarily focused on K-12 efforts. Wonderful people, brilliant people with tremendous experience, most of it in K-12. Occasionally when I'm around these folks, I tease them a little bit and say they're the blankets and milk people, because I remember those days when they made us take naps, and now I live in a world where they won't let us take naps, and my doctor says I shouldn't have milk. So I kind of miss those days. And that's where they come from. Well, let's be honest, this is a culture that really struggled to meet the new obligations of Compliance University. They're being mandated by the president to get much more involved in our work, and the personnel weren't entirely there. The workload increased dramatically. They're learning about us at the same time we're learning about them. And we've seen in just very recent times more people with higher education experience entering the Department of Ed and becoming more prominent. But they're playing catch up just the same way we are, and it could take some time for us to get used to each other. As a result, they will communicate with us in ways that are very familiar to them in the K-12 context or in other areas of compliance, but may not be familiar with us. And I don't know that we always recognize the miscommunications that are taking place. It's funny to watch. I mean, funny in a weird, funny sense, I suppose. But when the Department of Ed told us in Title IX we needed grievance systems, I have a really clear idea of what they were trying to communicate to us, but I think a lot of us actually weren't entirely sure what they meant by grievance. They sort of assumed that we knew what they meant without really taking the time to realize that we were miscommunicating. In law school, they teach us a case about the ship Peerless, and it's an amusing case because two people were talking about the ship Peerless. It's just that they weren't talking about the same ship. They thought they were because it had the same name, but they were actually talking across each other. And that happens in this field. So part of our job is to translate, is to listen carefully to what our regulators are saying and try to understand where they're coming from. They're trying to do the same with us. So I'll flip over to the Department of Justice for a minute. And these are crime fighters. And I don't know if you've been to the Department of Justice building. I have recently, and the security is extraordinary. These folks deal with some of the worst people on the planet: terrorists, violent criminals, drug dealers. This is no fooling around. These are hardcore law enforcement lawyers and prosecutors, and they come at things a little bit differently. They haven't been terribly involved in higher education for a while. You'd have had to have been in this business for quite some time to remember the last big intervention periods of the Department of Justice. Suffice it to say that when they look across to their friends in the Department of Education, they see a different kind of skill set, a different kind of regulatory mentality. Perhaps you've noticed this if you've read some of the missives from the Department of Justice, particularly around Title IX. There's no fooling around. The language is often very determinative and even perhaps intimidating. But they also, like the Department of Ed, have not had a lot of experience regulating us. They're used to dealing with a different kind of population, shall we say. They've been mandated to work together, and let's be honest, they have two very different cultures. The culture of the Department of Justice and the culture of the Department of Ed are very, very different. And the Department of Education came to Compliance University without all of the legal weapons that the Department of Justice routinely has at its disposal. I think what we have seen, and this, of course, is a more advanced unit of study. If you're interested, we could talk more about this in a later module. The Department of Justice, Department of Ed rather, has done a really significant job of increasing its power to regulate. There's a whole story there. Different cultures. So let's get used to this idea that all they've been mandated to work together. These kids don't necessarily play well together on the playground, and they're really coming from different places. Who programs the robots? Where do they get their programming? Well, it comes fundamentally from Congress, regulatory through legislation. But the White House plays a critical role too, and I think you kind of figured this out because you've noticed that so much of our compliance mandates of today have originated in the Obama administration, so it does matter who's in the White House and what their agenda is. But ultimately, the authority to regulate comes through Congress. Who reins in the robots? Congress, obviously, because you can't exceed your statutory authority, and you've seen debates of that type recently, particularly around Title IX. The White House can change directions, and the courts also can play a role in all of this. The court system will occasionally jump in and tell regulatory bodies that they have exceeded their authority. What influences robots? All of the above, and they are not oblivious to politics. They certainly are aware of interest groups and the advocacy that's out there. And yes, they do read the newspapers. I think particularly the Chronicle of Higher Education is commonly read. I'm not meaning to pick one publication among others, but it's pretty obvious that there is a dialogue that occurs in that particular publication among others. How do robots operate? Well, very rule-like, very policy-driven, and it originates from something that we know as the Administrative Procedure Act, which dominates a lot of the behavior. It sets the tone for how a robot can communicate with the field. The classic way is to make rules. Rule-making, though, is an arduous process, and therefore, and you may have noticed this, there's a lot more communication that comes out of regulatory bodies than rules. The rules are a subset, but there's a whole bunch more communication. Why don't they just speak in rules exclusively? Because it's a very difficult and lengthy process. Typically, to make a rule, you need to have a period of notice and comment. It could take months, even years, to get proper rules into place. The Department of Ed has a process it uses occasionally called negotiated rulemaking. They used it with VAWA Save recently. It's not used all the time. It's a somewhat of an alternative process, but again, it's also one that can be quite lengthy. Administrative agencies also can adjudicate. They essentially have a court function as well. Intriguingly, we don't often find ourselves in administrative court. But you might have noticed that a lot of our interaction around rules with the Departments of Ed and Justice has been more in the spirit of voluntary compliance, which is designed to avoid adjudication. But yes, they can take you to court. They can take you to their own court. Guidance. By definition, guidance is not a rule. Anytime you ask a robot, is this guidance a new rule? They're always going to give you the same answer, no. Because by definition, guidance is never making new rules. It's simply guidance. I don't know if you've seen The Matrix, but Morpheus doesn't make the rules of The Matrix, but he guides Neo through it. one way to think about it if you've seen that movie. One way I think about it, I don't know, do you have one of those navigation programs on your phone? I can't live without them anymore. I used to be able to find things with a map, but now I turn on my navigation program. And what I've learned is it sometimes tells me to do some really weird things, things that seem counterintuitive, but I do those things. Then later I realize that there was a reason for that. Now, I don't have to follow the guidance, but if I don't follow the guidance, I usually end up being late. And so there's an interesting interrelationship between guidance and the rules. Guidance is never a rule. It can talk about rules that exist and give guidance with respect to those. But if, for example, we choose to not follow guidance, when we are in non-compliance with a rule, that's something that will be taken into account. Why didn't you follow our guidance? Catherine Lamont issued a statement to us about Title IX, and she said the most egregious examples of Title IX violations usually occur where there's no Title IX coordinator or that person isn't fully functioning or supported. That's a message. It's a message of what we have found. So if you don't have a Title IX coordinator and there are Title IX violations, you might expect that that will be something that will have consequences. I find it amusing the Department of Ed and Justice often communicate with us in Dear Colleague letters, and they don't always feel collegial to us because it isn't the way we communicate with colleagues, but it does send a signal that our regulatory bodies do wish to work with us. As much as their activity may seem oppositional, they're really working to the very purpose that we are, is to try to make tomorrow a better day. It isn't always easy, and it isn't always as friendly as we might like it, or collegial in the classic academic sense, but it is designed to be collaborative. We see resolution agreements and letters of findings. Now again, technically, these are neither rules nor guidance, so therefore, you will routinely hear the Department of Ed say, the resolution agreements and letters of findings are specific to an institution and are not designed to be guidance or introduce additional rules. And yet, I read them and I see new stuff in there. Bet you do too. And then you think, this may not be guidance, but I'd be pretty foolish not to be guided by these. It's a subtle point, but again, it's important in understanding how the robots communicate, because in their world, they can make rules, they can adjudicate, they can give guidance, they can enter into voluntary resolutions through agreements and letters of findings, and these things are conceptually distinct in their world. We have to make sense of all of it, so in our world, often the language in resolution agreements and letters of finding is very, very significant to us. May I go back to earlier slides in this program just for a second? The power of the law sometimes is the command that underlies it. And so very specific mandates to schools often get our attention because we realize those things might be told to us, and they were told to a specific institution. So there's something a little ironic of all of this, is the stuff that the robots might think of as the softer side of Sears is actually stuff that may be more commanding to us. Robots also like to communicate informally. They've been doing more of this on their websites, blogs, press releases, speeches, media advisories, sending representatives to meetings, and even through the regional offices, creating a dialogue. This is a regulatory system that wants to be more communicative and wants to learn with us. They're coming out and speaking. May I give you a tip? Typically, when someone comes from one of the regulatory bodies to a meeting or even to your campus, they're programmed with certain information they're designed to deliver. But some information will only be gained if you take time to ask the right questions. Attacking the robots won't get you anywhere, so if you spend your meeting with a representative of the robot complaining that guidance is actually new rulemaking, they're going to say it's not. And they'll stick to that message no matter how angry you get and how much you push it. The rocks will simply bounce off the metal armor of the robot. But if you ask the robot, is there anything you'd like to share with us that we haven't asked before, you might get something interesting out of that. So you want to learn to communicate with the robots. when they come to your campus or you visit with them, understand how they are programmed to operate. Working with the system will get you much more effective communication. Fighting it will simply bring you to dead ends. Let's take a minute to talk about compliance in modern generations. I have some thoughts about this. A lot of folks do, but I think, again, it's good to think generationally. So what I'm hoping to do is to stimulate that kind of conversation, not just with this module, but others to follow. Millennials. Many of us have a large population of millennials, and we're getting towards the end stage now of millennial intervention. Of course, as they become older learners, we'll see them appearing in our higher education facilities as well. A couple things I've noticed. Very pod behavior with a lot of millennials. They're very friend-oriented. And so their idea of compliance and risk management is often generated through a friend group. Can I be very specific? Title IX, as they know it, is often Title IX the way their friends know it. Their decision to use our systems is often driven by what their friends think they should or should not do. And so we have to understand that this population is very friend-driven, and our compliance work, our risk management work, must be sensitive to the fact that these are folks that are very much connected to groupthink, special friends, BFFs. Very digital, we know that, and in fact the government has recognized this. We see a lot of regulatory effort these days coming out specifically designed to improve our digital interventions because that's where people are living and learning. Family. We hear a lot of talk about helicopter parents. That's great. I'm not sure I particularly like the image. I'll let you chew on whether you do or not. It has sort of a Vietnam flavor to it. The Huey helicopters coming into the LZ. Yes, they sometimes show up really hot with us before our first meeting with a lot of parents is not always productive. But what I see is I see a lot of people who are proxy learners. A lot of family members thought their college experience was a signature moment in their lives, and they're actually returning through their family members, their sons and daughters, who are often their friends. And in fact, what we're seeing is a generation of students who have been subject to a very elaborate construction process that in many cases occurred even before birth. We're looking at parents who are bringing students to us in an end stage of construction, frankly, and they expect certain outcomes from us. They also want to participate in that learning primarily because they have been participating in it all along. They've been going to their K-12 meetings to meet the teachers, IEPs, and perhaps most importantly of all is they've seen to it that their sons and daughters were raised also by professionals, so that a lot of young people have spent a significant amount of their rearing time in mentored environments run by professionals, preschool programs, after-school programs, daycare, you name it. What you're seeing is a construction project of a human being. You're at the end stages, and I think the families expect outcomes. They expect them efficiently, and it really shows you a lot of the motivation that's going on. I also think that we kid ourselves if we think that our clients are simply the people who are sitting in the classroom. Many of you do discipline work out there. You know exactly what I'm saying. You'll be sitting with a student trying to have a conversation about responsibility, and they're texting mom or dad to get the right answers. You actually are interacting with a consumer who's behind a consumer. They're coming as a group in family units. Multiculturalism dominates with this group, and in many ways they just don't understand those of us from the 70s. Earlier in the program, we talked about dyads. The conceptualization that I was raised with in multiculturalism was pretty simplistic in retrospect. You were black or white, male or female, gay or straight, abled or disabled, old or young. These were categories that were drilled into me so that I just assumed that that's what life was, that you were assigned one of these, and it followed you through life. That's not the world that we live in today. We live in a world of choice and continuum. And young people today, millennials in particular, recognize that a dyadic way of looking at multiculturalism is just completely foreign to them. It's about choice and continuum. Hence, when we ask them, are you this or that, they often check other, because they don't even really understand the concept of a this or that, a binary or dyadic opposition. These are folks that were raised around esteem. They were mentored. They were rewarded. They were protected. And you can see the pressure for things like trigger terms. I was raised by two Depression-era parents, and rewards were few and far between. I didn't get a lot of compliments. I got a lot of critique. And I think my parents didn't imagine themselves as my friends. Even late in life, it's not a role that we've really played with each other. I think they felt it was their job, their sacred obligation to challenge me so that I would grow. And I didn't receive a lot of rewards. I think what we've learned, though, is that young people respond to rewards perhaps more appropriately than they do to punishments. And so you have a generation that's more familiar with reward and, shall we say, even bribes than they are with punishments and harsh consequences. I think it's quite a shock, actually, for a lot of young people to come to higher education because they've used to being mentored and rewarded and bribed and protected, and all of a sudden they're in an environment where you break a rule and you're in trouble, and you better watch out. There's a lot of places that you can get in trouble, and it's actually fairly difficult to win awards. We don't hand them out the way that they're used to in other environments. It's a culture shock, and I don't know that we've fully appreciated just how significant it is. Resiliency is often discussed with millennials. I'll leave it at that. We know that mental health issues have dominated with this generation, much higher rates of mental health challenges than we saw in the past. And you could look at this as a negative. I don't, actually, because what it tells me is that the ADA and 504 are actually working. We're getting people into higher education who were excluded in the past. Advocacy. This is an advocacy generation. I have a thought, I have a feeling, I have an idea, I can connect with people on social media, and I can get the change that I want. And we see this quite a bit. I think it's a little startling to baby boomers and Gen Xers who did not have the way to advocate that young people do today. And I'm kind of applauding the success of advocacy efforts out there. I think it's kind of cool. Debt. We have loaded millennials with a lot of educational debt. I believe that education debt now tops $1 trillion. It is a mass market of lending, and it will be a cultural dynamic throughout their entire lifetime is managing money and debt. Very dualistic culture. One thing about millennials that we have to keep in mind in compliance work is anything that we're doing, they're doing it their own way. They have their own systems. They have their own Title IX system. They have their own healthcare system. They have their own academic support system, their own discipline system. Everything we do, is reproduced by millennials. And that means if they don't think our systems are functional, they simply avoid them and access the systems that they've created. I hate to admit it, but I know it's true. There's a Title IX system out there, a vigilante system. I've actually seen evidence of it where young men will beat up another young man and claim it's a spontaneous altercation, but when you look at the evidence, there's no way it was a spontaneous fight. It was a hit. But certain young men are willing to take the possibility of being involved in an affray to try to bring justice as they see it in the community. They may even be telling people who've been victimized by Title IX issues, don't go to the system. The compliance system, the risk management systems don't work. Our system does. It's important to realize that we're competing with people who will simply do it themselves if they feel our systems aren't operating. But what energy there is, if we can bring them to our systems, these are people who are doers and will participate in a system they believe has meaning. Can you see why I put such emphasis on the spirit of the law? If we can't motivate them to why we're doing this, chances are they'll go their separate way. And if they think we're not sincere in our compliance and risk management efforts, chances are they'll simply pick their own systems over ours. They tell us about socialization a lot. They complain. They're fearful that they're not as socialized as previous generations. My dad almost lived to 100. And one of the things he said as he was leaving the planet is that he felt sorry for young people today. They seem locked up in their houses and weren't given a chance to interact the way children in other generations were. That's his perspective. I don't know what yours is, but I will tell you that studies routinely show that millennials report concerns about their socialization. We can help with that. And I think it senses something very important about generations and learning, is that a huge meta learning opportunity is to help people improve interpersonal relations, conflict resolution, how to find really solid people in your life and build durable relationships. Those were things I think we took for granted in previous generations, that we just assumed people would figure that out. But I'm not so sure it's that easy in this world, and I think it's something that higher education could certainly help with.